Like all the speakers before me, I would like to thank Zohar for putting together this wonderful event, and I would like to thank everyone here for contributing to this very important conference. We're now at our last session. You probably have noticed that I'm not Taisu. I was just recruited by Zohar at the last minute to moderate the session. I told him I don't have a jacket. He said I don't care. So it's his fault, it's not mine. So we'll start with Ofer Eldar, the rise of dual class stock IPOs. Ofer, please.
Thank you very much, Zohar, for the opportunity to present. I will start also by saying something a little bit personal. So I'm in a long line of academics that Henry really helped jumpstart their career, and basically was my mentor for many, many years. And I have to say something that, you know, we all here because of the brilliance of the book, but also I want to mention how much Henry did for, you know, many, many young academics. I mean, the things he did for me are really, truly incredible. And I have many stories, which I will save for the 50th anniversary of the book. But, you know, just to mention a few, he literally started a new program at Yale so that I can apply to, you know, overcome all the GSD rules so that I can come to Yale and do the GSD and many, many other things. But one thing I really miss is really all the hours spending going over ideas and trying to think through my own research. And it's literally, I would go to his office, it would be 2 p.m. and I would get out at 5 p.m. Just talking about ideas and different types of organization and things like that. Okay, so with that, so thank you, Henry. And let me say, I can only hope that you know, my generation of academics will also find the time and generosity to do the same. So with that, I'll talk about the rise of dual class IPOs. This is joint work with two finance professors, Yael Rauterberg and Lubomir Lidov, and also Drew Vagerwal, who is also a student at Yale, who I understand also was Henry's RA for some time. Okay, so there's been a wave of dual class IPOs in recent years. And many of these firms are software or technology startups such as Google, Yelp. So how big is this phenomenon? So this figure shows the percentage of dual class firms out of the total number of IPOs. And this percentage basically rose from about 8% to almost 30% of IPOs in 2019. So the question in the paper is, why do firms adopt dual class IPOs and why do we see the current trend? And there isn't really an account that in the literature that addresses these questions. And specifically, given all the pressure that exists on public corporations to remove anti-takeover devices, we would actually expect the opposite. We actually expect fewer dual class firms. Also, VC firms that are generally the main source of capital for startup, at least historically, used to require companies to adopt stronger governance at the IPO, things like independent directors. So, however, there are other developments in the private market that really tilted the balance of power against investors and in favor of founders. So the amount of dry powder in investment increased dramatically from 1994, specifically by VC firms. But these investors are also bringing in other investors, such as private equity funds, mutual funds, et cetera, et cetera. Moreover, I mean, we talked a little bit about cloud computing. Businesses need less capital in order to run their businesses, as shown in by UN Snanda and World Corp. The startup cost and also the cost of doing business actually declined substantially as a result of the introduction of cloud computing in 2006. So many startups in industries like software, business services, retail, leisure, can reach very high valuations without ever raising any VC capital. So as a result, founders increasingly maintain control over startups, and there is a lot of anecdotal evidence of this, and we cite some articles from the Wall Street Journal and the New York Times on the slide. Now, a major problem of studying this phenomenon is that there's a big variety of dual class firms. So we know about Facebook, of course, but in the full sample of IPOs, just under 50% of dual class firms are founder controlled. So Chipotle is one example. The controller here was McDonald's. McDonald's wanted to both raise capital in public markets and maintain control over Chipotle, mainly for strategic reasons. So eventually this didn't work out very well, but the key point is that clearly the economic motivation of McDonald's are different than that of Mark Zuckerberg. So the main contribution of this paper is really to open the black box of dual class firm and provide a sort of a descriptive analysis of dual class adoption over time. So we classify the IPOs by different types of controllers, founders, VC, PE, et cetera, et cetera. We calculate the wedge for different types of controller and for the public shareholders. So the wedge for the public shareholder is naturally negative because they have more economic rights than voting rights. So this is kind of a measure of the potential agency cost. And the wedge of the controller is positive because they have more voting rights than economic rights. And that's a measure of the economic incentives of the controller. Now, I should say that the seminal studies of dual class stock, they really focus on the wedge for directors and officers. And that was part of the motivation for this classification, because we realized, for example, if you look at Chipotle, the wedge actually comes out as negative, suggesting this is a low agency cost firm, which is clearly not the case. So using this classification, we find that the increase in dual class structure over time is really driven by founder-controlled firms, not other type of dual class firms. The main finding of the empirical analysis is that greater availability of private capital is associated with a higher probability of founder control and the size of the wedge. And we also document the adoption of different types of sunsets, and we find that sunsets are less likely to be adopted by founders when they have stronger bargaining power. So the data I already mentioned, the main, a big part of this is the data collection. We have about 6,000 IPOs with 615 dual class IPO. So let me show you some descriptive statistics. So we show separately the statistics on single class firms, founder controlled dual class firms, and other dual class firms. So you can see that founder controlled firms tend to be much younger than other dual class firms, about 11 years, as opposed to 29 years for other dual class firms. They also have lower book value of assets. Maybe we heard, right, they don't have much assets. R&D is actually lower, surprisingly, but we also merge the data to data on patents, and we find that the value of patents for these firms, for the founder control firm, is substantially larger. Okay, so here we show the percent of dual class firms by controller type out of the total number of IPOs. So just under half of dual class firms are basically founder controlled. The rest are kind of scattered. The second category is the company controlled dual class firm. We also have joint control, that's the purple bar, joint control by VC and a founder, and also VC controlled and PE control, et cetera, et cetera. Now we also show the data for each type of controller. We show so we show this basically same thing, but before 2006, the first part of the sample, and after 2006, right? And we can see that the largest change is in founder-controlled firms. I mean, the percent of these firms basically more than double. That's the blue bar in the picture. Now, we also see the emergence of this joint control by the VC and the founder, right? It didn't exist before 2006, and VC control emerging after 2006. Okay, so we also show you the average wedge, right? Basically the difference between the voting rights and the economic rights expressed in percentage points. And you can see that the founder wedge is generally much higher than other categories, than in other categories of dual class firm. The wedge is about 25%. And this suggests generally, right, that the founders want more voting powers and less economic exposure. We also show the same, again, before and after 2006. And we show that the largest change, we see that the largest change is with founder control firm. the founder wedge basically increased by about 6%, and other categories stay mostly stable. So if you think about it, even conditional on being sort of founder control, the average wedge between voting and economic rights increased over time. Okay, so the main focus of the empirical analysis is really the testing this bargaining power hypothesis, and the idea is that founders value control over their companies, that value control over the companies more than other investors, right, are more likely to go public if they can maintain control after the IPO. And when founders' bargaining power is stronger, the firms are more likely to adopt dual class structures. Now, when do founders have more bargaining power? Well, we think in two circumstances. So the first is when, right, where they can raise capital in the private market as an alternative to going public, and essentially when there's more private capital available, essentially more money is chasing deals, there are higher valuation in the private market, and that makes it less desirable for the founders to go public unless they can maintain control after the IPO. So this leads to the first prediction that the more private capital is available at the industry level, the more likely that a firm is to go public with dual class structure. Secondly, it's when the firms need less capital to set up and operate the business, and we focus again on technological shocks, specifically the introduction of cloud computing in 2006 that reduced the cost of setting up and operating businesses in the software and services industry. And this leads to the second prediction that firms in industries that basically benefited from cloud computing are more likely to adopt a dual class structure after 2006. Okay, so I start with the first prediction. We have two empirical specifications. In the first one, the dependent variable is an indicator variable for different types of controller. It can be dual class or any controller, essentially any controller, founder, PE firms, company, and other. In the second, we regress basically the wedge, whether it's public wedge or the founder wedge, et cetera, et cetera. And the variable of interest is basically the availability of private capital in the industry level, or what you see in the slide as IPC. And we use two proxies for IPC. The first one is the industry dry powder, which is the amount of funds raised by the VC funds, but not yet invested, based on the industry in which each fund made the largest number of investment. And the second one is basically VC industry financing, which is late stage venture capital investment at the industry level. And the rationale is that late stage VC investment may be viewed as sort of as an alternative to going public. Now we have in this specification industry and here fixed the facts. So this means that where we identify these betas are really driven by changes to the availability of capital at the industry level over time. So just to give you a sense of what happens in the data, in panel A, we show trends in the percentage of dual class structure out of the total number of IPOs in the top 5 industries that experienced increases in the private capital availability. So not surprisingly, I mean, business services industry really, which include a lot of software companies, is one of them, right? Is the top one of them. And you can see in the red bars, clearly there's a big increase in the percentage of dual class firm. And on the other side, you see even a much greater increase in the percentage of founder control firms. Now, when we do we do the opposite exercise, right? In panel B, we look at the top 5 industries that experience a decrease in private capital availability. We see basically the reverse development. Interestingly, one of those industries is the media industry, the traditional media industry, which paradoxically was the main predictor of dual class structures in the 90s. Okay, so these are basically the result from the main specification where the dependent variable is an indicator variable for dual class or different types of controllers. So you can see it in each column. And what we find is that industry dry powder predicts dual class structure and founder control. So things like 1 standard deviation in dry powder is associated with about 3% higher probability of founder control. And that's very high given that, in the total sample, we have about 5% of IPO firms of founder control. So as expected, Dry powder does not predict dual class structure when the controller is not the founder, something like a private equity firm or corporations. Okay, so this is basically the main finding. I'm going to, we show the same thing with the result with the wedge. We have lots of robustness tests which might come up in the question part of the presentation. But I'll move to the second hypothesis, right, which is about dual class and the impact of technological shocks. So we said founders are more likely to adopt dual class structures when they need less capital, right, to operate the business. So we used the introduction of cloud computing in 2006 essentially as a shock to the firm's need for private capital and the cost of doing business. These industries include software, services, finance, consumer information, leisure, and retail. And we see it anecdotally, right? So a lot of firms, a lot of startups reach the IPO stage without raising much VC capital. So example is Viva that did a $4 billion IPO, but raised only $7 million from VC firm. So again, to show you what's going on in the data, we see that the increase, if we split firms by whether or not they belong to the cloud industry, we see that the increase is mostly in cloud industries. And when we look more carefully at the type of controller type, again, you see that the increase in founder control is mostly in the cloud industries. And we split it further and we look at VC-backed IPOs, where arguably there's more of a kind of a bargaining story between the VC firms and the founders. And we see, again, there's some increase in non-VC backed IPO, but again, the increase is most stark in VC backed IPOs and cloud industries. Okay, so here we basically show this, what I just showed you in pictures. We can show you this in regression. Now, if I have a little bit more time, I'll say a couple of things about sunsets, because sunsets are also very important for dual class firms. These are provisions that basically dictate the terms under which the dual class structure will basically be terminated. So the two main ones are time sunsets that provide that the firm will convert to a single class firm within a specified time, for example, 7 years. Ownership sunset convert the firm into a single class when the controller's economic stake falls below a specified percentage. So we can see again, what's interesting is, ownership sunsets actually adopted more than time sunsets, which is interesting in itself. But again, what is interesting is that founders don't generally like sunset, and especially they don't like time sunsets. And we look also at trends over time, and we split firms into, founder control firm and non-founder control firm. These are all dual class firm. We can see that, there is some increase in the percentage of sunsets among founder control firm, but the trend is much weaker for founder control firm as compared to non-founder control firm. So we also do some regression analysis. I think in the interest of time, I'm going to skip it, but the basic idea is that we do find that when founders have greater bargaining power, which again, we sort of instrument with the introduction of cloud computing, they're less likely to adopt the important types of sunsets, in particular time sunsets and ownership sunsets. Okay, so with that, I will conclude. I say the probability, we show that the probability of dual class structure and sunset provisions at the IPO is a function of the bargaining power of the founders, and greater availability of capital and less need for such capital strengthened the bargaining position of founders and led to an increase in dual class IPOs. I think there's scope to think about the theory behind it. There's a lot of questions about policies, about whether it makes sense to make it easier for firms to raise private capital relative to the cost of raising capital in public markets, because if it's much easier to raise capital in private markets, that doesn't just change the nature of the number of firms in public markets, but it can also change the type of firms that actually go public. And we see that specifically with the increase in the percentages of dual class firms. So with that, I'll happy to hear your feedback and questions.
I suggest you take questions. There was one here, and then by show of hands. So maybe you take
Thank you.
several and then decide.
Right? Yeah.
Okay.
My question is basically confirming the fact. When you say that in more startup company, the founders keep control, that means that after IPO, by using the dual class, or even before IPO, the Silicon Valley founders keeps control, and the VCs cannot take control. If it would be the latter, that means that the picture of Silicon Valley changed since that Ron Gilson wrote a paper on the put option or call option. Okay, call option of the control. So actually, in Japan, the dual class is not feasible. Japanese founders are very stick to the majority of control. As a result, the size of the financing is limited, and that is the most important problem of Japanese VC industries. So my question is there not a serious problems happen in Silicon Valley yet because of such a phenomenon? Because that if in fact VCs hard to get control in Silicon Valley investment, is there no serious problem happened yet because of that?
I'll take a few questions.
Yeah. Yes.
Jack.
Yeah, maybe from Merit and me both. I don't know to what extent Merit will add to it, but don't you need, isn't there a missing part of your empirical design? So isn't the question is there a discount on the stock price that the founder would otherwise receive per unit of value created for conditional on the condition of the markets you're identifying, which would mean that in a favorable market, the founder faces less of a discount from doing a dual class IPO and therefore would be more willing to do it on that basis than in a market without that supply effect. In other words, don't you need to be looking at stock price at which the IPO is done per unit of value created, whether cash flows or whatever else you're going to use?
Yeah, I mean, it comes from just the idea you would think that dollars chasing deals would just affect share price, and therefore if we see something else going on, and its structure would be determined by whatever's efficient. So if we see something else going on, isn't it the kind of trade-off Jeff is describing?
Great. So take Jans.
Okay, I thought this was really a fantastic paper. I do agree that, the bargaining power shouldn't affect the allocation of rights or control. So I wonder if there's something new about the industry that suggests that there's a reason why maintaining founder control is more valuable in cloud-based companies. And one potential reason would be that, so to use a comparison, right? So when Chipotle went public, right, there was sort of McDonald's played a huge role. And the argument here is that Chipotle knows how to make great Tex-Mex food or Mexican food. I'm not a Chipotle customer, I don't know. And McDonald's really knows how to, run a huge food company. And that's their expertise, and they bring that to the table. And maybe, here maintaining control for the founders is more valuable because established companies don't really know how to run these businesses. And that explains why the arrangement's different. Thank you.
Yeah, I'll respond. So I'll start with the first question, and I'm happy to follow back up again. There are a lot of foreign companies actually in the data. I mean, the results are all robust, excluding the foreign companies. But I should say, in part because there are some restrictions in especially Chinese companies. There have been a lot of restrictions. There were a lot of restrictions on issuing dual class stock, and many of them listed in the U.S. And actually the numbers for foreign corporations is staggering. Is almost 50%. So about the discount, that's very tricky. I mean, we had results on valuations, which I took out of the paper for the time. I mean, and might be a subject of another paper. What we find is actually founder control is associated with higher Tobin skew post IPO, but not if the wedge is very high. So if you think about firms like Snap, where the wedge between voting rights and cash flow right is very high. The founders have very little economic stake in the company. We actually see that Tobin skew is declining, subject, of course, to all the methodological issues that we have with Tobin skew. So it's hard to say whether there's a discount, right? We need a good comparison group. But generally speaking, founder wedge is actually associated with higher value. So I guess the other question about Ian's question about welfare, this paper doesn't say anything about welfare, right? So it's almost like a prediction about what happens when private markets are more attractive for founders, right? So maybe that's efficient to have lots of dual class firm, right? There could be a bunch of reasons why, and so I generally agree with that, right? So and actually we are trying to work on a follow-up project that partly in part will focus on the innovation angle, right? And try to figure out whether there's a relationship between the control structure and innovation metrics. One thing we do in the paper, which I didn't emphasize in the presentation, is actually a lot of people looked at dual class and they try to look at R&D, for example, and they don't find a relationship between dual class and R&D, which is sort of surprising. And for us, it's even it looks like there's a negative correlation. But we actually matched the data to data on patents from Kogan et al. And when we look at the value of the patents, actually positively correlated with founder control, but not with other types of control, right? So which I think is interesting. So and would suggest that this could be an efficient structure, right? For especially for in the technology sector, right? So.
Okay, so you have 3 minutes, so you should take like 2 questions and respond very quickly. I'll leave you the choice.
Okay, Albert.
Hey, so great paper. You mentioned earlier at the beginning of your talk, and based on our paper too, VC backed. When the VC gets more involved, other kinds of corporate governance indices generally improve. Do you see similar things happening here too? I mean, as the founder gets more control, does that mean less independent directors, less rights given to the shareholders, and so on?
Yeah. So historically, VCs didn't like dual class stock. That has changed in the sample period, and we see it. If you look at post 2006, suddenly they're more amenable to dual class. But actually, the VCs are very important. They come out as really important in the analysis of sunsets. So I didn't have enough time to talk about that. But you can see that the rate of dual class firms where VC firms actually share the control either with the founder, share the control, or basically the controller. You see a very high rate of sunset provision. So this suggests that even though they have become, willing to tolerate dual class structures, they still exercise monitoring by requiring the firm to adopt the sunset provision, which is I think very interesting. 5 years, 10 years, you have different time frames.
Last question.
Two things. One is regarding Jeff's comment. It seems to me that at least it's plausible that you're paying as a potential shareholder for the value that you're getting from the founder and for the promise, essentially, that he's going to stick with the firm and help run the company. So it's quite possible there's no discount at all, but a premium. And the second comment is WeWork. How does that fit into your story, other than the fact that they didn't quite make the IPO?
Yeah, that's a great question. So WeWork, is outside of our sample, right? Because it's a failed IPO. So ultimately, everything we say is about IPOs that actually ultimately succeed. But that could be another an idea. I mean, clearly, in the context of WeWork, you can say the bargaining power was part of, of the reasons for the governance breakdown. Although again, it's a one firm, right? It's a one firm, and we talk about a big sample. So what we see is actually, related to your first point, that actually we typically see a premium for dual class, contrary to what we used to say. So with that, thank you.
Thank you very much. And our next speaker is Mariana Pergandler. Mariana, do you want to share screen? Okay, perfect.
Okay. Well, thank you, Zohar, for putting together this wonderful event. It looks like there has been some form of competition between different stakeholders or patrons in Henry's enterprise. Everybody thinks they have a stake because they read something and learned something. Now we are hearing from colleagues that Henry is such a wonderful colleague and they benefited so much. We heard from Rainier and Richard how wonderful Henry is as a co-author. But I want to echo Ofer and say that a highly privileged class of patrons is that of Henry's students. It is really amazing. If you know Henry, you'll know that he's very conscious of his time as a scholar. He, at some point, told me he was very upset that his doctor told him that he needed to exercise every day. I said, "What's up? I do that." And he said, No. I'll be wasting time from my articles to just, walk or ride a bike. And so it's so amazing how much time he has devoted and energy and love he has devoted to his students. And I think we're really the most privileged class. That unfortunately does not make us owners of the Hansmann enterprise. We are not really homogenous. I think we have different interests. My presentation will be very different from Ofer's. Actually, that makes us debtors, and we cannot possibly repay our debt to Henry. So now we have a huge debt for the generation to come, and I think I feel like I fall short, and I saw this theme in Ofer's initial remarks as well. I must say, you see I have a different title now. After Richard's remarks, I realized a title could not have partitioning in it, so I changed it. I hope Hansmann likes the new one better. So in addition to ownership of enterprise, Henry has also made foundational contributions to the legal and economic theory of legal entities. I want to build on some of these themes during my presentation today, so I will present them to you first. First being the essential role of organizational law. That is not just a catchy title. This is a major idea. Before this idea, law and economic scholars tended to regard corporate law as simply contract law. And in fact, Hansmann and Crackman showed that law is constitutive of firms as we know it. Law is very important in binding third parties and allowing the firm to serve as a nexus for contracts. The second theme is the unbundling of corporate separateness in the broader idea of asset partitioning. So in their work, they decenter the element of limited liability that had occupied scholarly attention today and identify the very important concept of entity shielding, which is the opposite of limited liability, requires law and serves to shield the firm assets from shareholder creditors. Another very important idea that I will stress today is that Henry has recognized that firms can have different boundaries for different purposes. Specifically, he said that the efficient control boundary of the firm might be different from the efficient asset boundary of the firm. And I will claim here that this has important implications for law. Also, even though most of Henry's work is descriptive of reality and makes us see things that we haven't seen before, he has also advanced some normative claims. And it's interesting that even though he said asset partitioning is essential, he has advocated against excessive or all or nothing partitioning. And I'm here referring to his famous defense of unlimited liability for corporate tort. So the end of history guys are actually care about stakeholders, and this is proof of that. And also about his more recent work with Richard Squire, distinguishing between external asset partitioning and internal asset partitioning, and claiming that the former should be stronger than the latter. So look at what we'll be doing here. I will be arguing that regulatory partitioning is an essential role of organizational law. I also want to further unbundle corporate separateness by claiming that regulatory partitioning differs from asset partitioning, and they should be subject to different boundaries, to different criteria. And we'll also advance a normative argument against excessive regulatory partitioning in corporate law. I must say there is also an evolutionary component in my presentation. This is another theme of Henry's. He has, well, there's the end of history of corporate law, the law and the rise of the firm. So he likes to make claims about the evolution of the organizations. I'll make one as well. I'll say that there has been a rise of entity transparency or regulatory departitioning in corporate law over time and across jurisdictions. I regard it as generally a positive, efficient development. We can go further in some jurisdictions, but ownership structures still matter for this aspect as well. So this presentation will be a combination of recently published work and some works in progress, including a recent work in progress with George Georgiev. I don't know the precise fractions. I mean, I was very impressed by Jill Fish. She had a very clear vision about the amount of each paper that was in this. I don't, but it is a broad combination. So the state of the literature is Hansmann and Crackman, or Hansmann, Crackman, and Squire, that says that the fundamental economic role of legal entities is the provision of asset partitioning, separation between the essence of the firm and those of shareholders. We all know there are exceptions to asset partitioning. Those are known, generally known. One of them is known as veil piercing. In this project, I want to suggest that there is another type of legal separation provided by the corporate form, which is regulatory partitioning. Regulatory partitioning is the separation between the sphere of the corporation and that of shareholders for purposes of the imputation of legal characteristics, rights, duties that have nothing to do with the separation of assets. I argue that this dimension is also subject to exceptions, and we should separate both forms of exception, and I suggest here a cute term, veil peaking, to denote exceptions to regulatory partitioning or regulatory departitioning, if you will. So let me give you an example about what I have in mind when I talk about regulatory partitioning. Take Alice, a shareholder of Apple Inc. Suppose Alice is French, Alice is Black, Alice is bound by a certain non-compete agreement. Alice has been debarred from contracting with the US government. Regulatory partitioning means that none of these legal characteristics or obligations are attributed or imputed to Apple. You can see from this example that regulatory partitioning with respect to non-controlling shareholders is essential for large firms with numerous shareholders, as essential as entity shielding. Otherwise, the legal status of the firm would fluctuate depending on the identity of its several and transient shareholders. However, if Alice were the controlling shareholder of Apple, the law would often, not always, attribute legal duties, rights, or characteristics to the corporation for purposes of the imputation of nationality, race, contractual obligations, sanctions, and so on and so forth. In fact, because of the economic importance of control, there are numerous exceptions to regulatory partitioning. Antitrust doesn't take regulatory partitioning very seriously. There's a famous decision by the US Supreme Court saying that a parent and a wholly owned subsidiary do not count as two entities for purposes of a conspiracy. It's only one thing. There are numerous cases of constitutional law, some were mentioned this morning, about the imputation of free speech rights or religious rights under a statute to a corporation. There are numerous cases of tax. In fact, an expert opinion by Oliver Hart, which he cites in his Nobel Prize lecture, was one of the inspirations behind this project. He argued there that because it's a wholly owned subsidiary, it's the same thing from an economic perspective, and therefore the law should not grant the same tax benefit to a subsidiary that it grants to a separate firm. This regulatory partitioning dimension is quite important in having a broader, more realistic view of the relationships of firms and of the role of the law. Something that is missing from the nexus of or for contracts is the state. And yet some firms flourish or die because of their relationship with the state. And regulatory partitioning allows corporations to act as a nexus for regulation of their relationships with the state. So we saw here, we heard during this conference the view that we care about stakeholders, but protection should come from the state through tax and through regulation. Well, let me tell you, regulatory partitioning is a huge mechanism for regulatory arbitrage. So thinking about the boundaries of regulatory partitioning and departitioning is very important for that dimension as well. So I would like to show that asset and regulatory departitioning differ. Those are different dimensions. Of course, they go well together. Some of their functions are shared. Both contribute to modularity, to abstraction between the firm and their shareholders so that firms can be priced irrespective of shareholder identity and also help firms serve as transferable bundles of contracts. But they also serve different functions and entail distinct trade-offs. And this has normative implications. I argue that the very restrictive criteria typically required for asset partitioning, such as fraud or commingling of assets, should not apply for issues of regulatory departitioning. And most cases that we see of regulatory departitioning or veil peaking come about when the law in question, be it the Constitution, the contract, the international treaty, the statute, is silent about the treatment of related parties. And I'm arguing here the veil piercing test should not apply. Instead, you should look at those cases as cases of statutory, constitutional, contract interpretation and just do regular gap filling in view of the purpose of the legal instrument at hand. And this morning also, Rick Brooks mentioned the great deal of confusion and conflation regarding corporate separateness and veiling. And I want to suggest here that the debate has been plagued by a fallacy, the type of fallacy known as a fallacy of equivocation, which happens when a term is used with one meaning in the premise and with a different meaning in the conclusion. And the term that has two meanings here is separate. So the premise is legal personality provides for a separate, in the sense of distinct, nexus for the imputation of legal rights and duties. And that is absolutely correct. But then people have the conclusion that legal persons should be treated as legally separate in the sense of independent and insulated from shareholders in all contexts. And this is a logical fallacy. It does not follow from a conceptual perspective, and it is a poor policy choice. And by the way, the same thing would apply to natural persons, something that also came up this morning. So I'm legally separate from my daughters, they're natural persons, but our legal spheres are related. I'm vicariously liable for their torts under Brazilian law. So both things are different for legal persons and for natural persons. Now I want to switch gears a little bit to talk about current work, which is about regulatory partitioning or departitioning. I'm calling it entity transparency in corporate law. I'm not talking about shareholder liability at all. This is all about regulatory departitioning, about the applications of legal rules that have nothing to do with imposing liability on shareholders or on entities. So is a common scenario. You have shareholders of a given parent corporation, and the parent corporation has a wholly owned sub. Let me tell you, this is a realistic scenario. We know from Richard Squire how many subs large public corporations have. And the question here is that how would corporate law react to this scenario? Would a shareholder of the parent company be able to sue directors of the sub? Would they be able to approve major asset sales conducted by the sub? Would they have access to the books and records of the sub? Would they know about executive compensation paid by the sub and have a say on that? So this is the types of questions that we are approaching in this project. What does the literature says? Not much. It's not a question that has been dealt with upfront. There is a very important paper by Melvin Eisenberg called Mega Subsidiaries. He was very impressed in the 1970s with the rise of subsidiaries in large corporations, and was very much concerned that this could be used to reduce shareholder rights. And then he made an argument for pass-through shareholder rights, for what I'm calling entity transparency. His article was very influential in Germany. It ended up being indirectly influential in Japan. I don't think it was so influential in the United States, actually, when the Delaware Chancery Court confronted a similar issue in 2004. The question was whether the parent company, whether parent company shareholders had the right to approve a major asset sale by the sub. Leo Strine said, wow, what a difficult question. On the one hand, on the other hand, this is so, in the end, he didn't decide. In the end, the Delaware statute was amended to provide such pass-through shareholder rights. By the way, not the only amendment in the decade. The same statute was amended to provide access to books and records of sub. What I'm saying here is that there is a trend in the US and abroad. Comparative corporate law scholarship also doesn't say much. What it says is, well, some countries have special laws on corporate groups with special rules. Germany is the paradigm. Other countries just apply regular corporate law to corporate groups. UK is the paradigm. But then you have the question, I mean, what does it mean to apply regular corporate law? Does it mean to apply it in an entity transparency fashion or in a formalistic fashion that does not allow for pass-through shareholder rights? And I can tell you, I've just conducted I even counted the references to subsidiaries and holding companies and groups in the UK statute. And it is highly concerned with this topic, actually. And it has been one of the leaders together with the US in the adoption of entity transparency. So the claim, the evolutionary claim here is that there has been a silent rise of entity transparency in corporate law around the world. So this is the evolutionary trend. Differences remain across jurisdictions. So in France, in South Korea, in Brazil, this is very common in common law jurisdictions. No recognition of double derivative suits. Many countries, you don't have the right to approve or have a say on compensation paid by the subsidiary. So what I want to say here is that in all countries, the trend is toward greater entity transparency. So in the Brazilian in the Brazilian context, without a change in the statute, courts used to deny shareholders access to books and records of the subsidiaries. More recent decisions allow for such access. So I think I'm claiming there is a general trend, but it has been faster in some countries with respect to others. Why? Then you have the question. One part of the explanation is that ownership structures differ. Entity transparency is most functional with respect to wholly owned subsidiaries. And we know that in the US and the UK, most subsidiaries for tax reasons, historical reasons, are wholly owned. In other countries, partial subsidiaries and pyramidal structures are less common. But also we argue that a problem has been the lack of conceptualization because what scholars and courts think they know is that veil piercing is exceptional and requires fraud, and to allow a double derivative suit would overcome a fundamental element of legal personality, and capitalism would be destroyed without knowing and being completely aware of this broader trend. And the claim here is that those differences are unimportant, but so far neglected impediment to investor protection in other jurisdictions. So my conclusions is that we have to unbundle the functions of organizational law. Regulatory partitioning plays an essential role. The boundaries of asset and regulatory partitioning are not and need not be the same across different contexts. There is a pattern of rising entity transparency over time and across jurisdictions, meaning that entity transparency more often is more often following the control boundaries of the firm rather than the asset boundaries of the firm. But the lack of conceptualization of this phenomenon has aided the persistence of formalism to the detriment of investor protection and other corporate law objectives. So let me end just thanking again, and especially Zohar, especially Henry, for everything he has done for us. And I just want to also thank Marina. For those close to Henry knows how much charm and energy she has brought to the Henry enterprise, and dinners, they wouldn't be the same without her. So thank you so much, and I look forward to your questions and comments.
Thank you. We have 3 people who want to ask questions from Zoom. So we start with Richard, and then could take questions from the room. Richard, please.
Thank you. Mariana, this is a really interesting paper. It's possible that I've already made my only possible contribution, which is to encourage you inadvertently to get partitioning out of the title. But I will try to say something in addition that might be useful, or at least to encourage a bit of further development, I think, of a theory that you're pointing toward here. And you talked about the importance of conceptualization. In my work with Henry that you mentioned on internal and external partitioning, we had, and I don't know if we said it this cleanly, but we should have, but we had a kind of a notion of what is a legitimate use of a legal entity or an asset partition, because that's what we were thinking of entities are for, where an efficiency is being created. And then when is the entity being abused? And so then some kind of departitioning remedy, and veil piercing is an obvious one, but there are others such as substantive consolidation, when that would be used, either because there's a perception of abuse or just because it would be convenient. And we had just one theory of legitimate use of entities there. That's what we were all thinking about, which was the economics of asset partitioning and the way that that can reduce information costs for creditors coming out of the Hansmann-Crackman kind of framework. But if you go to the States and you talk about all these different forms of departitioning or veil peaking, I like that term, and so on, you potentially are implicating a broader set of theories that the state would have about what is a legitimate use of an entity and what is an abuse of an entity where the entity should be disregarded or looked through in some way. And I'm just wondering, are you developing a catalog of legitimate and illegitimate uses? Does legitimacy depend on the jurisdiction? Does it depend on the area of law in which the piercing or the peaking is happening? That's it.
Thank you, Richard. Let me just be clear that I'm combining different papers here, and so I'll see. Well, I'll give you a response. So first, about what entities are for, and I don't know how much I emphasize that in my presentation, but in terms of actual uses of entity, regulatory partitioning possibly explains a greater number of subsidiaries than asset partitioning. I think you and Henry might agree with that. So in terms of descriptive reality, regulatory partitioning is really, really important. You raise well, what is then legitimate? Are there legitimate uses of asset partitioning? Well, I think there are actually legitimate uses of regulatory partitioning, even if it's used to evade legal regulation. So if you think about the history of the holding company and pyramids in the United States, they were actually created to circumvent protectionist rules governing, requiring local incorporation of utilities. I think that actually, I don't know if it would regard it as legitimate or not, but I think that probably might have contributed to greater efficiency of the US economy. And this is still done to this day. So what I'm not offering here is an overarching theory of legitimate or efficient regulatory partitioning and departitioning across various areas of law for all kinds. I cannot do that. Actually, my point is the opposite. So the answer is quite context specific. I don't think there is a general answer about even free speech rights. I think it depends on your country, your constitution. I think the corporate form can survive either way. I have my own preferences regarding that, but I think it won't affect asset partitioning, because some corporate law scholars said after Citizens United, oh, this is so risky because the corporation has limited liability. Well, it won't go away. Those things are completely different. What I am doing, however, in the second project, the ongoing project, is offer a theory about corporate law. And what I think here is that with respect to wholly owned subsidiaries, for sure, partially owned subsidiaries will have some questions regarding, regarding line drawing, but certainly for wholly owned subsidiaries in corporate law, so long as you have chosen a certain shareholder right, it makes complete sense to apply it in a pass-through fashion. I don't think there are very good arguments against applying in a pass-through fashion. Then it's just empty arbitrage. If you don't like the right, you go ahead and abolish that shareholder right, but it should be applied in a pass-through fashion. And I think there's just a small difference, perhaps, regarding the framework in your paper with Henry of internal versus external partitioning and what I'm doing here. I actually here talked about the group in my example, but in the paper, we actually have a broader view, and we also capture things that go to upstream and also to individual controlling shareholders. So I think that sometimes there is a good case for regulatory partitioning against natural persons in a way that is probably different from the your analysis regarding asset partitioning.
Thank you. We have 3 more minutes. I'm going to take 2 questions from the room here, and maybe you'll comment afterwards. So Jeff and then Roberto.
So, hi, welcome. So the Hollinger case involved the potential elimination of the shareholder right to vote for the sale of substantially all assets. And you identify Leo Strine's concern about it, which led to later amendment of 271. What about in the case of the very common case in which a merger is achieved through acquire sub, which cuts off, as a formal matter, the rights of the shareholders of the acquirer to vote on the merger, because the constituent of the merger is acquire sub, the triangular form. So is it so are you prepared to say that ought to be eliminated, that this common way in which mergers are structured in the United States, we ought to see a pass-through of rights to the shareholders of the acquirer as a part of your theory?
Thank you, Jeff. And then Roberto, and then response.
Thank you. So I was wondering, from your conclusion seems to suggest that formalism is bad in this context, right? And but in some cases, formalism in the corporation has made this structure into a spectacular engine for growth and the creation of wealth. So do we really need a general theory of regular partitioning, or it's more of a case-by-case basis, and those are very all different tools with different functions, and we need to assess them normatively in different ways?
Yes, Mariana, please.
So great questions. I'm not prepared to go that way with mergers. I know that that can be used to circumvent shareholder approval requirements. There are also all sorts of short-form mergers that reduce other types of shareholder rights as well. But I think there's some differences regarding mergers that they do more than just be an element of reducing the rights that we would otherwise have. So I think that is a harder case, but something that we certainly should explore. I should say that it's very interesting that we see the Delaware reform as following the Hollinger decision, and I think that's absolutely right. That's what happened in the U.S., but it's noteworthy that Japanese law had enacted a bunch of departitioning reforms just a few years before and others thereafter. So I think there is really a global trend, and while we sometimes get stuck with the development in the U.S., I think there is a broader trend that is driven by functional exigencies, and then those are clear in some cases, say this indirect asset sale rather than others such as mergers. Regarding formalism as a spectacular engine for growth and creation of wealth, I do think that in some reasons they make perfect sense to uphold regulatory partitioning. I think I gave an example of that. I think also that so I think also that it can be abused. So insofar as it's an argument for context specificity and a careful view of the objectives of the legal rule in question, I think I'm completely on board. But I want to stress that this is not currently the stage of the debate. I think people are really, whenever such an issue come up, and you have like amicus briefs signed by 40, 50 law professors, whenever you have an asset partition, a regulatory partitioning issue, then they say, well, this is like veil piercing and it's so demanding and it shouldn't do it. And so this is what I'm fighting against. Sure, let's look at the regulatory objectives and see if it makes sense, but let's forget about the tests that can be quite useful for asset partitioning, but are quite less so. They're not for regulatory partitioning.
Okay, Mariana, thank you for a wonderful presentation. And now we get to our last speaker, Gabe, who's going to talk about the evolution of control across the public-private divide.
Okay, wonderful. Well, thank you, Zohar and Richard, for putting on this absolutely wonderful conference. It's been really intellectually lively. I think Alan and Luigi are having an active argument about shareholder primacy here. It's, if you have notes, it's very intellectually stimulating. And the book we celebrate deeply influenced me. So like many others, I wanted to take a minute to express my gratitude. So when I think about why the ownership of enterprise is a transformational text, like many have noted, I think its basic question is, why do market economies become capitalism? And that question is a little like Coase's question, why do firms exist, which is it's a question that blows your mind when you ask it, and then you're amazed that progress can be made in answering it. So at dinner parties, when I meet people who will indulge me, I ask individuals in finance, why does investor ownership emerge as the dominant form of business ownership? One of the first and most forceful insights of the book is that there's nothing baked into the DNA of ownership that requires that any of the patrons can and do own the firm. We could have an entire economy that consisted exclusively of nonprofits. And people say to me, the superior risk-bearing abilities of shareholders are determinative. And then I think one of the second and most forceful and mind-blowing insights of the book is that it cannot be one dominant factor because every one of the patron groups sometimes do prosper and flourish in parts of the economy. When I think about why this book is so worth celebrating, I think it's because it's really hard to make a contribution to world culture while studying corporate law. But we know it can be done because Henry did it. And so I think he's up there for me with the great social theorists like Weber and Veblen, but it becomes a bit of an invidious comparison to compare them to him because I think he's right. Like his theory still stands as the best one, and that can seldom be said of great social theory. At a more personal level, I think the generosity of his interests, the humanism he has about methods, the exquisite wry humor we've seen on display, and the critical but compassionate way he engages is just an incredible model for the field. And whatever, I'm just grateful to be included and grateful for Henry's presence and work. Okay, so the core argument of this project is that a series of capital market developments have led to a transformed relationship between the public-private divide erected by securities law and the public-private divide created by investment fund regulation. And that these two very different public-private divides now interact in a way that their designers could have never foreseen or intended, and which is unlikely to be optimal. So that the last conclusion, which is the normative one, I put forward in a provisional spirit, but to just give a roadmap, I'm gonna basically sketch the two public-private divides to remind us of the basics of the law, sketch a couple of the developments that led to the transformed relationships between them, talk a bit about how the divides interact, a problem with that interaction, and maybe some potential policy proposals to develop on the basis of that. Okay, so in the space of a single decade between 1933 and 1934, the federal regulation of securities markets is adopted. And in 1940, the Investment Company Act and the Investment Advisors Act create the federal regulation of investment funds, pooled vehicles of capital that invest in financial assets. And the basic structure of both divides is very similar. On the privates, both divides partition the relevant universes, either all issuers of securities or all investment funds, respectively, into two buckets, public and private. And on the private side of the ledger, the issuance and trading of securities is highly restricted, but those issuers are otherwise lightly regulated. And on the public side of the ledger, the issuance and trading of shares is highly liberal, but you're otherwise extensively regulated. So the centerpiece of the regulation of public companies, operating companies, is mandatory disclosure. But the centerpiece of the regulation of investment funds is a panoply of mandatory rules that profoundly structure how registered investment fund works. No one really calls them public investment funds, though we could. We just call them registered funds, right? So just to remind us of the dividing line for all issuers, if you want to stay private, you've got to avoid any of the three triggers for becoming a public company, which is making a public offering, listing on a national stock exchange, or going over 2,000 shareholders of record. If you're an investment fund and you want to be a private investment fund, you basically have two options, and you only had one in 1940, which was 3C1, now you have 3C7. 3C7 is all your investors have to be qualified purchasers, and you're neither making nor contemplating a public offering. The 3C1 exemption, which creates the public-private divide for funds in 1940, says you can't have over 100 investors. An important piece of the legislative history here is that the creators of the public-private divide for funds couldn't possibly have contemplated and did not contemplate that private funds would go on to have the incredibly important role they do in modern finance. So there were no private funds in the modern sense in 1940. The very earliest hedge funds, private equity funds, venture capital funds, all post-date 1940, arguably in terms of significant asset under management, it becomes much later. And having poured through the legislative history of 3C1, it's not a rich record, it's a scanty one, but it's obvious that David Schenker, the general counsel of the SEC, and the SEC, which basically drafted the initial version of the legislation, just thought a fund with under 100 shareholders would have no social consequence, i.e. private funds are socially unimportant funds. They were clearly wrong about that. There's a really rich prior literature here. The public-private divide in securities law has a very rich literature. They're building on a lot of work here. Investment fund regulation is a less of a locus of scholarly work, but obviously John, who's here, and others have made great contributions. Likewise, the effects of securities law and investment fund regulation. So the changing relationship in the paper, I sketch a bunch of capital market developments that I think are really important, but I want to emphasize two here because of the time limit. And one will be familiar from Jeff and Ron's work as well as others. Jonathan Burke, I think, also does interesting things with this fact, which is a change in the nature of how stock is held from direct holding to intermediated holding. And the second is the growth of private capital and the accompanying changes to the nature of the equilibrium between staying private and going public. The effect of these changes will be, the bottom line here for, I think, part of the explanatory premise will be the most important owners or the owners of a majority of public company stock are registered funds, and the owners of a majority of the stock of our most valuable private companies are private funds. So on both sides of the public-private divide, you have the most important classes of owners being funds, but they're very different kinds of funds. And in some sense, my point is we shouldn't, and we didn't intend that to happen, and we should be suspicious that it's a desirable feature of the architecture of our capital markets. Two ways to think about that result are that this transformed relationship leads fund regulation and securities regulation to be partial substitutes for each other in a way that couldn't have been true 50 years ago. So if you want to allow retail investors to invest in private corporate equities, you can just allow direct shareholding, or you could allow them to have greater ease to invest in private funds. The second one is that securities and fund regulation, which I think in 1940 were created as kind of ancillaries, distinct bodies of law, have become one body of law for operating companies, and then investment fund regulation has become basically the body of law for governing their owners. And so that raises fundamental normative questions about what the right criteria are for evaluating fund regulation. So the Federal Reserve has pretty good data on the ownership of corporate equities. If you create a time series, you can see a familiar stylized fact, which is direct household ownership has imploded. And if you look at the way the Fed calculates the household sector of direct ownership, it's as a residual, it's very fraught. So the blue line is overstated here. It's direct household ownership of corporate equities. This goes public and private is much smaller than it is here. But you can see that that direct ownership disappeared or declined precipitously. Institutional ownership rose enormously. And of course, the important story for public markets is the rise of registered fund ownership of public equities. So pension funds were really important to owning public equities in the 80s, not so now. It's really mutual funds and exchange traded funds, the two big classes of open-ended funds, own what is now effectively a majority of the stock of public companies. Private fund ownership, obviously, it is not a science. It may not even be an art to value private companies. But if you try to think about the value of the most, who owns the equity of our most valuable private companies, it's going to turn out to be funds. So these are stylized facts in some vague sense because we're valuing private companies, but the aggregate market cap of private equity and venture capital-backed private firms constitutes a large portion of the total value of private corporate equities, and it constitutes, I think, the vast majority of the right tail of most valuable private companies. As part of this empirical sort of operationalization of this project, I'll try to get to at the end. I pull a bunch of corporate charters for private companies and then financials on them. And if you do the total valuation of current US unicorns, you get $2.5 trillion. So if the Fed tells us private corporate equities are worth $12 trillion, 200 something unicorns are a large part of that. And that's true even if you apply Gornall and Strebulev's kind of benchmark revaluation of private unicorn valuations. By its Series D round, the majority of stock of the average unicorn is held by outside investors, most of whom are funds, but not all. Growth of private capital in the last 30 years, and especially the last 10, maybe the last 20, we've seen an astonishing growth in the capacity of both funds and operating companies to raise capital in private markets. So this is just a graph showing, or a figure showing us from the data pulled by Vargas and all from the SEC. But you can see that whereas a lot more money used to be raised in registered offerings in public markets than private markets, Reg D, which is the most important and most active way to raise money in private markets, is just consumed capital raising writ large. So most capital raised in the economy is done through Reg D, which allows unlimited offerings to an unlimited number of accredited investors, people who earn over $200,000 a year. Private equity has been around for a long time. We've been talking about it for a long time. It's still stunning to see, this is from Forum PF, from the private funds forums, still stunning to see how much private equity ownership has risen. Most of that capital being raised by Reg D is not by operating companies, it's by fund issuers that are then financing operating companies. Okay, how do the two divides interact? I'm going to be really quick here, but the basic theme is fund regulation profoundly shapes the behavior of investment funds. And because who owns a company matters to that company's operating performance, the regulation of funds profoundly shapes the ultimate outcomes we get out of companies in the economy. And I'm also going to say, but though I think I'm relying largely on prior work here, that obviously securities law also affects the behavior of funds importantly. What about the regulation of registered funds is important? There are a ton of important things. Registered funds are subject to extremely exacting disclosure obligations. You probably just couldn't run a lot of the most successful private funds as a registered fund because of the disclosure obligations, because of the extremely restrictive regulation of capital structure. You can't issue bonds. You can only get debt up to the 1/3 of the assets under management from a bank. There's an effective prohibition on performance compensation. And most importantly, there is the redemption mandate imposed on open-ended funds that profoundly shapes their behavior, because in order to maintain the net asset value of the fund and not have constant economic frictions for your owners, you're induced to invest in highly liquid and accurately priced securities. So I think there'd be the funds that own public and private companies would obviously act really differently, even if the law didn't shape their behavior, but the law really profoundly shapes their behavior and exaggerates the differences, I think, between how registered and private funds work. It bakes into the model of registered fund behavior a level of passivity and foregoing control we otherwise wouldn't observe. Okay, so on to my normative worry. Thank you, so. On to my normative worry about questioning how the two divides interact. Here's my worry, which is the developments that have led to how the two divides interact have led them to basically inadvertently align. Private funds, except for hedge funds, which are obviously an important part of the story that is not an important part of my story, but it's obviously economically consequential. Other than that, private funds own a large portion of private company stock by value, registered funds, public company stock. The core consequence of this is that we end up sorting for firms along two very important dimensions at the same time, which is how do you raise capital and who owns you? So if you want to think about this from the perspective of the firm, which is maybe more intuitive, but obviously less important to social welfare, from the perspective of the firm, you face two decisions when you consider going public or staying private. And those two decisions are, what issuance environment do I want for my shares? How do I want to issue my shares? How do I want them to trade? And the quite different but related question of, who do I want to own me? Do I want private funds that have a strong appetite for control, or registered funds to own me? But that's maybe a clear way to think about it. It's not the important way to think about it. The important way to think about it is obviously social welfare. And from the social welfare perspective, the question is, what is the socially optimal issuance environment for this firm's securities? Is it something like private markets, or is it something like public markets? And what's the socially optimal shareholder base for this firm? Is it a shareholder base that in public markets is pre-populated by lazy and indifferent registered funds, basically? Though we have rich and complicated and important arguments about how active they'll be, they're not active compared to seeking directorships, taking on huge control blocks, getting ongoing access to material non-public information. It's just not a thing registered funds do. So I'm worried that our current structure forces companies to be sorted along both of these dimensions at once, and that seems like it can't possibly be optimal. Okay, what do we do on the basis of that? Really hard to come up with policy implications. Why? Because the public and private markets are rich and complicated ecologies. There are a bunch of economically important dimensions. And also, besides trying to optimize both ecologies, a lot of people have an interest in optimizing the balance of firms between public and private markets and trying to make sure firms go public to an incidence. I think, I'm skeptical of those arguments. But here are a couple of policy implications. The third one is the one that goes directly to my worry, which is I think it provides us with some new reasons in favor of issuer choice. What does issuer choice mean? The most moderate version of this argument would be something like, let's make Reg 144A a little easier. One way I think to think about private markets is Reg D has been a huge success. The primary markets for capital raising in private markets work extremely well. The secondary markets work a lot less well. And I think there are a lot of reasons for that, but part of it's legal friction. So maybe 144 could work better. A bigger picture thought that I've just bat around in my head, and I'm not at all sure would be a good idea, is Merritt and Roberta had a battle in the 90s about whether we should have issuer choice basically for operating companies. But I think even if you're skeptical of issuer choice for operating companies, I'm tempted by the idea that giving funds greater choice over the securities law applicable to them might be a desirable thing. But that's a very provisional thought. So I'm almost out of time. Two other kind of implications. If we're going to rethink the public-private divide, which I think the SEC is really interested in doing, we have to rethink both divides at the same time, the fund and company divides. And I think we have to ask new questions about whether the current fund dividing line makes sense. You know, and I think John and Alan Farrell, I think were key to me on just knowing what the dividing line was, but also realizing numerosity. 100 people, there's no collective action problem for fund control. So having a number-based threshold for fund owner, for the dividing line between public and private funds doesn't seem to be a very good foundation. So there's other stuff I'd love to talk about, but maybe I'll just leave it there and turn it over to questions if there are any. And I'm very much looking forward to all of your thoughts, and I'd love to hear them.
So do you need help in taking questions, or can you handle it yourself?
I think I could handle it myself.
Okay,
right?
fine.
I just got tenure, you know. Jeff, please.
Congratulations.
Thanks.
So the question here is whether the law really matters or the business really matters. And you know, in effect, the claim that I associate with Ron and Bernie is that actually the success of a private fund in the private market is the lock-in. They raise the money from the limited partners for a fixed period of time. So the partners can't redeem. The limiteds can't redeem, but the forced exit because of the limited term. And that it is that structure rather than, you know, the difference between being what piece of the 40 Act you're applying that determines the success of this particular injection of money and ability, et cetera, to the private market. And yes, the NIMSIA change in 2006, right, that meant an entity, counted the 100 differently is very important to the flood of money, but the structure of the fund itself, the business elements of it were critical, not the legal constraints that it has to be in effect a closed as opposed to an open-end vehicle.
Yeah, great. So I think that so firstly, I think it's a great question. So you definitely need to try to figure out to what extent are these differences a function of law, rather than a function purely of sort of economic fundamentals and differences. And I think there are lots of reasons to think the law is pretty important. And I don't know if I'm going to come up with the example that goes most directly to your comments, Jeff, which were really rich. But here's one way to think about it, which is fund control behavior changes enormously between immediately pre-IPO and immediately post-IPO to a much greater extent than fund ownership. So if you look at the way in which like venture capital and private equity funds exercise control over the companies they own, they often continue to own a very significant stake for up to 3 years after a firm goes public. Sometimes they unwind their position in a year, but often it's perhaps surprisingly, it takes up to 3 years. And you can look, you know, I get certitude about this maybe from the conversations I've had with the general counsels of those firms, but I think you can also just see it from the disclosures they make when they go public about how they're changing the way in which they engage with the firm. And I think their control behavior completely changes. The way in which they have consulting firms that sort of go in, their ongoing access to material non-public information. So one way to see that the law really matters is public market securities law, I think, imposes very significant frictions on private fund ownership. And so the private fund exercise of control changes dramatically when a firm goes public, far more than the nature of just straightforward ownership changes, which it doesn't change that much for a couple of months or a couple of years. Merritt, please.
Yeah, I think this is a great project. But one thing you didn't talk very much about is closed-end funds. And I'm just, it sort of at some level, it seems like it makes sense that closed-end funds are a way of collecting public money to invest in issuers that want to, where the other factors suggest the private market is the best way to go.
Yeah, great question. There are business development companies, which I think Rainier might have written a paper about, and maybe Ron. There are a couple of weirder creatures in the menagerie, which is a huge Hansmannian I should be studying more. But there are a couple of other creatures in the menagerie that you might think do a better job about allowing private forms of control to enter public markets. I guess the short answer for closed-end funds is that they seem to have such significant pathologies that they have become completely inconsequential in terms of assets under management. So they're not doing what we might have wanted them to do. And it's been a couple of years since I read the sort of research on closed-end funds, but the sort of, and John's here, so maybe he can remind us. But I take it that they have an inefficient operating structure that has led them to those losses, and maybe that's why they're not solving this problem.
Yeah, although I guess I wonder whether folding in one other feature like that they terminate at 10 years or something like that might solve many of those problems.
No, I think that's great. I think if we, it might be a little like talking about SPACs too, which is if they had a better structure, they might actually be a really interesting entrant, even if you think they're not right now. John, please.
Yes, I can agree that SPACs are investment companies. So following up on Merritt's point, what about interval funds? To me, one of the great puzzles of the present market for publicly registered investment companies is that we don't see many funds that redeem on a periodic basis rather than a more or less continuous basis. Starting in, I think, the late 90s, the SEC allowed a closed-end fund to commit to periodically tendering for its shares, which creates a kind of intermediate vehicle that doesn't redeem on a weekly or a daily basis as required by the Investment Company Act, but also doesn't never redeem like a closed-end fund. I can't come up with an explanation for why those things are not more popular. It seems totally sensible to me, especially for things like retirement saving, where people genuinely don't need daily liquidity and are hurt by it, actually. A second question is, well, what about hedge funds? Hedge funds largely invest in public equities. And I'm wondering if you have an explanation as to why. It's a vehicle that sort of sits uncomfortably along your divide. And then a third question would be, it seems like maybe taxation could be part of the story here. Registered investment companies are taxed very differently from partnerships. And one wonders, given the partnership taxation structure of most private companies, is it more tax optimal? Is it more optimal from a tax perspective for a partnership to be owned by another partnership rather than by a registered investment company?
Yeah. Great. So they're all great questions, and I don't know if I'll be able to do them justice in the short time left. I guess a couple of thoughts on each of them. Maybe hedge funds first. Like hedge funds certainly suggest to us that one of two things is true, and I think some of both is true. Which is one, Jeff's totally right that just economic features of public markets matter a lot to fund behavior. And so the fact that private companies are generally more sensitive to the value of the exercise of skill control means that they're going to attract funds that have a greater specialization in providing skilled control. So I think part of the answer is just hedge funds are specializing public markets because public markets are partly call for the economic fundamentals of activist type interventions. Another thing, though, which is more part of my story is, yes, fund regulation shapes fund behavior, and fund behavior shapes company performance, but securities law also affects funds. And I wonder whether we might want to be tweaking the way in which securities law affects funds. So Section 204 of the Investment Company Act, as well as just the vigorous prosecution of insider trading law in public markets, makes it extremely tricky to have a director sit on a board and have ongoing redemption in your fund. So I think there's some reasons why hedge funds don't, why registered funds don't, which have ongoing constant liquidity, don't seek the same forms of control that hedge funds do. So basically, I think hedge funds are just like, there's not the inadvertent alignment is not perfect, and I wouldn't want to argue it is. What about RICs versus partnerships and the tax consequences there? I'm afraid that every year I tell myself I'll understand tax law better, and every year I don't get around to it. But I think part of the reason the blue line for direct household ownership doesn't decline more is important changes to tax law that make direct shareholding in some way more tax optimal. But I don't have a good tax answer to your question, John. But it's a wonderful question, and I'll carefully look into it. Okay.
Okay. So I had a question, but if there's one thing worse than being the last presenting is being the guy that insists to ask the last question on the last presentation of a 2-day conference. So I'll ask you afterwards. So thanks, Gabe, for a wonderful presentation.